Okay.
Okay. In accordance with Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, be advised that a notice of this meeting is made by posting on the bulletin board, town hall, and mailing to the officially designated newspapers a list of the meeting dates annually, indicating that this meeting would take place at the town hall at 7:30 p.m. on Wednesday, March 6th, 2024.
Corey Biller,
Here.
Michael Cohen,
Here.
Deborah Neves,
Yes.
Frank Sagamonte,
Here.
Sujatha Shan,
Here.
Srini Vijay,
Here.
Michael Zion,
Here.
Vice Chair Gaston Halbert,
Here.
Chair Beth Zoll.
Here. Thank you. Our first item tonight is approval of the minutes from January 3rd, 2024. A nice quick meeting. Did anybody have any comments or edits on the meeting minutes? Or Eileen, were there any changes that we need to know of?
No.
Okay. I move to approve. Do we have a second?
Second.
Thanks. All in favor?
Aye.
Any opposed? I don't think there's any abstains. We're all here. Oh, sorry, Debbie, you're not. You can abstain. Meeting minutes of January 3rd, 2024 approved. We have one memorialization, which we received via Ed Buzak. It's on application 23006. That was Spofford Holdings LLC for site plan approval. So nobody here would have provided, unless anybody provided comments following the sort of the second round we received earlier this.
Not after the second round. I think you just had one question that was answered.
Okay,
The only correction that was made the first time, but for some reason, when they did the second go around, page 2, line 40, they left Jason Tubell's name and should be changed to Benjamin Wine. Yeah, that was missed the second time.
okay. Thank you, reflecting the name change. Can you comment, give us the list of those who voted yes, who can vote on this? Just because our membership has changed.
Who voted? Corey, Allison, Michael, Deborah, Sujatha, Srini, David, Gaston, Beth.
Okay, great. Of those, does anybody move to approve the memorialization?
So moved.
Gaston, do we have a second?
One second.
Srini?
You were the
No,
motion.
Gaston was the motion,
That's what I thought.
Srini
Okay,
was the
thank you. Corey Biller,
Yes.
Michael Cohen,
Yes.
Deborah Neves.
Yes.
Sujatha Shan,
Yes.
Srini Vijay,
Yes.
Gaston Halbert,
Yes.
Beth Zoll.
Yes,
Thank you.
thank you. And we have one order of business tonight for discussion, and it's on ordinance 2662-24, proposing to repeal ordinance 2640-23. Graham is here to present and discuss and provide comments on the memo that was distributed to us. I think before you jump in, Mr. Warner wanted to make some comments.
Thank you, Madam Chair. Just wanted to,
Yeah, I don't know why
I'll stand back, just provide a little legal context, notwithstanding the fact that the board, maybe even the members of the public are familiar, but this is a master plan consistency review under section 64 and 26A of the municipal land use law. All zoning ordinances are to be referred by the governing body after first read to the planning board for master plan consistency review prior to second read and potential adoption of the ordinance by the governing body. And we have 35 days to make that report on referral from the governing body. It's not a public hearing. The planning board is not obliged to hold what would amount to a public hearing and does not require that there be a public comment or question. However, that does not deprive the public of an opportunity to speak to concerns raised by the proposed ordinance, since when the matter is returned to the governing body for second read and a public hearing, that of course is the opportunity for members of the public to weigh in, ask questions, and make public comment at that time relative to the ordinance, any ordinance, including this ordinance. The scope and authority of the board is simply to focus on whether or not the ordinance is, and it's the wonderful double negative, not inconsistent with the master plan, and that does have meaning. Because it is not, the standard is not if the ordinance is consistent with the master plan, but not inconsistent, which has been defined by the Supreme Court to mean substantially consistent. So inconsistencies are permitted, provided that the ordinance does not substantially or materially undermine or distort the basic provisions and objectives of the master plan. That is the legal standard pursuant to the Supreme Court in the Manalapan Realty case, 140 NJ 366, 1995 Supreme Court decision. And our consistency determinations as a planning board are given great weight by the courts, as is pretty much everything we do as a land use board, given a presumption of validity and great weight by the courts. So I just wanted to give that legal context. This particular ordinance, just one other item, if I may, to lay a little further, Graham and Madam Chair, thank you. It's my practice to have a resolution. The local redevelopment law and housing law for redevelopment plan ordinances and the municipal land use law for all other zoning ordinances, both of which require the referral to the planning board by the governing body before adoption or potential adoption, is silent as to by what means or mechanisms the board reports back to the governing body. It just simply says report back to the governing body. It could be a letter, could be a report from the planner. It's my practice to do, in essence, a template resolution, customized, but please do not read into the fact that I always put not inconsistent. That's not indicative or influencing any determination. It's just a template I utilize, and that's why that was distributed to the board members. The word not can be taken out, and it can become inconsistent just as easily, or whatever the board ultimately determines can be modified to the resolution. It's really just to give the board an opportunity, if it so desires, to not only make a determination that night, but to actually go the step of adopting the resolution, memorializing that determination, and then that resolution would constitute a formal report back to the governing body. So with all that legalese out of the way, now we get to hear the important stuff from our professional planner with the chair's permission.
Sure. So good evening, everybody. Graham Petto, serving here as board planner this evening. So I did prepare for the benefit of the board for this evening's consideration, consistency review memo dated Friday, March 1st, 2024. The report is fairly lengthy in content. So I just wanted to confirm, Madam Chair, if you'd like me to read through the report or how you'd like me to handle or summarize some of the general
Start with a
findings.
summary and then if people
Okay, and then we can address any questions. So we did provide a lot of initial context, discussion of our prior work on this project, and then consideration of the introduced repealing ordinance and its relationship to the master plan. I have a pretty extensive section that details summary of the site constraints and issues that have been identified since, effectuation of the site. And it, chiefly among those is environmental concerns, and then also relocation of DPW facilities and operations in order to maintain efficient and consistent level of service to the township residents during the process. Specifically relating to the master plan, this is subsection 2 on page 3 of my report. Starts to get into greater detail about the relationship specifically to the master plan. As cited, in the master plan envisions that use of the DPW site and surrounding municipally owned land as part of a large redevelopment or reuse scheme. And as presented in the redevelopment plan, that was just to do a portion of the site, just 1.78 acres of the 5.55 acres of the site in total. So here in this effort, in this vein, the opportunity to look comprehensively at the site again is what the master plan envisions, to look at that site comprehensively in a larger vein. Similarly, the Millburn Downtown Vision Plan does discuss the site and opportunities to develop the site in its entirety. And then specifically with respect to objectives of the master plan identified that would be not inconsistent regarding some of the site contamination. We've highlighted a couple of different objectives. Objective 6.04 to protect water resources and enforcing sustainable design practices. The site contamination that we've identified and that the environmental remediation analysis has yielded does identify some site contamination and protection of water resources within the township is an objective of the master plan. Objective 6.07 to support and adopt policies to protect and improve quality of surface and groundwater, the local and regional water supply, bioavailability of land, air quality, and the township's open and natural resources. So those are the high-level objectives that we felt could be advanced by effectuation of this ordinance before you for consideration. And then we did have some additional discussion that does reference the township's resolution regarding this project. And chief among those concerns is that, we've highlighted, this is in subsection 3 on page 4 of the report. We have 3 kind of key bullet points, kind of takeaways from the resolution that I think are important for consideration here as it relates to the property. The DPW site is contaminated and requires extensive remediation prior to construction, of which the cost and timeline for safe residential use of the site is presently unknown to the township. The township must first consolidate DPW operations displaced by the development, but the site for relocation of existing DPW facilities remains unknown, as well as associated cost, extent, and scope of required permitting improvements and costs to the township. And screening of the development site requires elimination of the township fire and police direct egress to Main Street. Presently, there is a direct means of egress, but effectuation of the development would eliminate that egress as they would become 2 separate entity sites. So those were the high-level items that were cited by the Township Committee in their review of the project and reconsideration. So just a couple of quick high-level bullet points. Obviously, there's a lot of content here. Happy to further address any questions that the board has regarding our summary review and findings.
Thanks. Did anybody have any specific questions or items that jumped out that wanted any clarification from Graham or needed any further discussion?
Well, I'll just ask some questions.
Please.
So the question would be, are we saying that, the development is not consistent with the master plan, or are we just saying, we're agreeing to repeat the repeal of the previous ordinance?
Maybe we can both, I guess there's a legal and a planning to
It's kind of a
where legal ends and planning begins is sometimes a gray area. But the standard is, first of all, this is a repeal of the redevelopment plan ordinance that is being considered. It's not the policy of it that's being considered by this planning board. It is simply whether it is not inconsistent, substantially consistent with the master plan per the
Project or the ordinance?
The ordinance repealing
Right.
the project, right, is what is being considered. So that is the ordinance before this board for master plan consistency right now. So if I understand correctly from the memo, and it would be appropriate for me to ask, if I may, Madam Chair, as a professional planner licensed in the state of New Jersey and as the planner for this planning board, and I believe this municipality as a whole, do you have an opinion with respect to whether or not this repeal ordinance is or is not inconsistent with the master plan?
Sure. So as set forth in section 5 of the advisory consistency review memo, I do note that based on the review that's outlined in the preceding pages, that I do opine and recommend that the proposed ordinance is not inconsistent with the township's master plan. The board can consider this report in making its determination whether the ordinance is not inconsistent with the township master plan. So
And that ordinance, again, being the ordinance
just to
repealing
repeal
the project.
the redevelopment plan.
The fact that the ordinance creating the redevelopment plan in the first place was found to be not inconsistent does not require the repeal of the ordinance to be found to be inconsistent. They are not mutually, inclusive, or they are mutually exclusive. So, and I take it your opinion with respect to the redevelopment plan initially, or that ordinance was that that ordinance was not inconsistent with the master plan, just like your opinion is with respect to the repeal being not inconsistent with the master plan, for the reasons stated. Is that correct?
That's correct.
I hope I didn't confuse it more than it already was. So, but it's the repeal that's being considered solely for consistency purposes.
Okay, Deborah, I think you would.
I did. So on page 2, in the bottom paragraph, you talk about the township's commissioning of a feasibility study to relocate the DPW. And I see that you quoted that the report is for informational purposes and is not intended to provide an opinion as to whether the project will be approved by the required agencies. But my question was, what was their assessment about the ability, the actual ability to relocate the DPW? Because that's not addressed in what you shared with us.
So I think, so there's kind of two components to that. One is that there is some initial scope that is presented within the 2019 report on feasibility. It does indicate that, you know, the DPW facility could be effectuated on portions of that site. However, since then, the state of New Jersey DEP has adopted new inland flood regulations, which may further encumber or change or modify what was reported in 2019. So that creates another layer of the unknown that we're not fully aware that is still valid from 2019. If that makes sense.
So this is more an issue of the new regulations that have been passed rather than what's in this 2019.
I think it's kind of a combination of both. You know, there are some issues that were cited in 2019, but things to the degree to which those have been modified or changed, or, you know, the validity of those has been changed. That's kind of also what's unknown at this point and hasn't been fully evaluated.
Fully evaluated by townships or by the state or?
But I think by the township specifically, as they would be pursuing a development of that site. So
Okay.
there has not been an engineering analysis or, you know, site considerations or, you know, looking at the new flood regulations or the delineation of the flood hazard area on the site and, you know, what facilities could be located within which portions of the site, for example.
Can you clarify, have both flood hazard maps as well as flood hazard building regulations?
So I
changed
don't,
since 2019?
I don't want to
Yeah.
say if the maps have changed or not, because that I'm not aware of, but the regulations have
Okay.
changed, yes.
And with the discussion about using the entire site for redevelopment, has there been any inclusion of police access to Old Short Hills Road? Because, you know, on the one hand, it didn't seem to be an issue when this was originally done, and then suddenly this is being put into, you know, your assessment in summary. So I'm just, and there's discussion about developing the whole site. So what was considered to be, you know, impacting the police access to Old Short Hills Road if the entire site were to be developed?
I think, I just want to clarify your question. So you're asking if the entire site were to be developed, would the access issue still be a concern, I think is your question?
Yes, because it wasn't discussed as a concern when we originally reviewed the other ordinance. So I'm just wondering about how it's become an issue now and, you know, how we're developing the entire site.
So I think it's important. One is a full site framework did not yet contemplate layout or configuration of features or placement of structures or those types of things on the site. So I don't think that was anticipated as a concern during the master plan process, and the downtown vision plan process, which were much more conceptual in nature and didn't really opine on the specifics. I can tell you that as part of the site process and, you know, starting to effectuate the parameters of the 9 Main Street project, the physical separation of the DPW facility from the potential 9 Main Street project was going to limit that egress point and create a physical barrier between those two. You know, I think there was some hope that there could be a little bit more of free flow connectivity, but that was not something that we were able to effectuate.
And is the police access in the master plan?
Identified as an item in the master plan. I can't speak to that specifically because I'm not sure. I don't believe so. So I just wanted to, that was a consideration of the township committee.
Okay, but when
Just
we're
by
looking at
reference.
it being not inconsistent.
With the master plan
Sounds like the police access is not necessarily something that we should be considering because it's not in the master plan.
That would be
to
correct,
begin with.
factually correct,
Okay.
yes.
Other questions, comments?
Yeah, so I think one thing that also needs to be considered is that, back when this was declared an area in need of redevelopment, I think that was in 2008, and then the ordinance that we're repealing now was contingent on that being an area in need of redevelopment. But in March 13th of 2023, in the Malenga versus Township of West Orange case, it made it more clear what's required for an area of need of redevelopment. And what that stipulated is that a municipality must determine that the current site that's being designated is detrimental to the safety, health, morals, or welfare of the community. By that standard, this never should have gotten declared an area in need of redevelopment to begin with, and the first ordinance that we're repealing now probably shouldn't have passed. Obviously, this is newer case law than what was available then, but given that, I think this clearly should not be an area in need of redevelopment. Do you have any opinions on that?
Well, I think I'll just,
case?
regarding that case, that's specific. So redevelopment has two components. One is to study and identify and declare an area to be in need of redevelopment. That case law is specific to that portion. This is, subsequent to that is the adoption and effectuation of a redevelopment plan. So I don't want to say it's not entirely related, but there's kind of a different phase of the process that case law is related to. That's, Mr. Warner, if you have any.
I'm familiar with the Malenga case. It's actually two Malenga cases. Malenga has been very busy in West Orange, and successful with respect to redevelopment cases, but and objecting to them. One was the library, one was the Essex Screen. I think that one was the library, the more recent one.
Mm-hmm.
But while I would concur with our board member and council members' analysis of that case and how it enlightened later what the criteria meant, and may well have led to a different determination at the time of whether or not this was an area in need of redevelopment. So I think it's very relevant in that sense. I do have to say that it might seem like an artificial vacuum that we're putting ourselves in now, but we in essence have to look at this particular ordinance at this time, and less with what may or may not have happened or should have happened with respect to the area in need of redevelopment designation and the ultimate ordinance being adopted or not, and more, does the repeal of that ordinance, is it at least substantially consistent with our master plan? We kind of have to assume we had the ordinance that we had, and this is a repeal of it. And what goals and objectives from the master plan are fostered by the repeal? I don't know if that helps, but it's somewhat of an artificial but necessary legal scope that we put ourselves in.
Sure, so then if the master plan and the downtown vision plan had suggested that the entirety of the site be redeveloped, in one cohesive block,
Mhm.
then I would say repealing this is actually more consistent with that element of the master plan. I think that's what you.
And that's what
getting
we've
at.
cited in
I
our
was just
report.
saying, yeah, that, irrespective of the area in need of redevelopment, the correctness after the fact or not of that determination, I believe, well, more importantly, Graham, a planner, believes that that's relevant to the objectives.
Yes.
It's a little unique because we're repealing an ordinance, so we're looking at the, you tell me, Garen, but I think my experience is a little, by repealing an ordinance, we're looking at, okay, what are the goals and objectives of the master plan that are fostered not by what we usually do, by enacting an ordinance, but by eliminating it.
Mhm.
So we have the double negative, not inconsistent, and then we have sort of, we're looking at what are the benefits of eliminating an ordinance as opposed to adopting one. So
Mhm.
this is not your garden variety of master plan consistency review, but it's not unique. I wouldn't say it's unique, and it's happening elsewhere. It's
So I
happened
think the
before.
strongest argument would be the contamination of the site. That you found the contamination of the site. Does the master plan contemplate, not building on hazardous waste?
I think
Areas?
Graham reflected, site contamination, bioavailability, and preservation were the three that I wrote down. I maybe use some.
Yeah, it's
other
objective 6.04, which is to protect water resources and enforce sustainable design practices, and objective 6.07, support and adopt policies to protect and improve the quality of surface and groundwater, local and regional water supply, the bioavailabilibility of land, air quality, and the township's open spaces and
So
natural
we're
resources.
digging up this hazardous site, potentially affect our water supply? Is that kind of the thread?
That is what, the preceding paragraph, we discussed the site contamination, then reference these objectives. That would be the relationship between those two.
And just, if I may, Chair, just to be clear, you're citing from our master plan re-examination, which was also an update
An update,
in 2018. So it was not just a re-examination, but also the adoption of a master
of the
plan
new master
in
plan,
and of
correct.
itself, which has bearing in the case law, reliance not only on a re-examination report, but an actual master plan. So I want to make that clear.
Which has had subsequent elements added to it,
To
which
it.
we're still evaluating this against the most current version.
Oh,
Yeah,
exactly.
okay, just, yeah.
Including one
Yeah.
that's a housing element fair share plan.
Exactly.
So,
Yeah,
yes.
yeah. Thank you.
Graham, the housing element and fair share plan
Mhm.
that was added to the master plan as an element of the master plan, as far as I can tell, I didn't see any reference to the 9 Main Street project being required to be done via redevelopment, correct? So if this is to revoke the redevelopment portion of it, would that also be consistent with that?
I mean, I guess the question is, it's as far as consistency, which is what the board's purview is here this evening. I think that the repeal of the ordinance, is specific to this plan, but I think that the board could consider this not inconsistent, as long as it's recommended that they continue to pursue and accommodate, the goals that are identified. So, in the housing element.
Right, and what I'm saying is that housing element and fair share plan didn't specifically stipulate that redevelopment was required, and therefore revoking the redevelopment shouldn't be inconsistent, right? If the redevelopment plan was not required by the housing element.
Theoretically, there are other means to which this could be
Correct.
effectuated. That's correct.
Yeah, I mean, it's certainly, we're receiving, in 2024, less than 1 year after we've adopted an ordinance, the pullback or the repeal of the ordinance. I went back and rewatched the meeting, thanks to YouTube, looked at the voting, reread your memo from before. I think what you're writing is compelling. I think, the hinge is this sort of new environmental information that maybe we didn't have at the time that now we understand could compromise the site. Relocation of the DPW, which you mentioned now, is something that's mentioned in the master plan and is something that, is consistent. So is that substantially inconsistent? That's, I guess, for us to determine. And also locating higher density development as appropriate in our downtown as opposed to adjacent to a mall or somewhere else in the outskirts. That was something that was intentionally included in the master plan re-exam. So I'm definitely struggling personally with, my interpretation of what is not, not inconsistent mean and what is substantially consistent.
And if I could add to the relocation of the DPW, which is opined and discussed in the master plan, the one area that the master plan is silent is how that is to be effectuated, the relocation of the DPW. And one comment that I had in this process is that it's kind of a piecemeal approach. It's looking to relocate half or a third of the DPW operations, which is that what the master plan intended is really kind of the question that I was grappling with, and I think that's something that the board should consider in this process. Is decoupling 1/3 of the DPW from the rest of the facility, is that what the master plan intended, or was it looking to relocate the DPW in its entirety from this site to avail it for redevelopment? So if it's the latter, then that is certainly, then this ordinance is certainly more consistent in that it avails a full relocation as one unit from the site.
Other comments or questions for Graham? Okay. Do we want to does somebody want to make a motion on ordinance 266224? So If so moved, you would move, I think, to declare it either not inconsistent or inconsistent, as you might prefer.
I'll make that motion. I move that we declare this ordinance to be not inconsistent with the master plan.
Okay, and do we have to make the decision on the memorialization now,
Well-
or do we do that following a vote?
Well, assuming there's a second for that motion, it would be consistent with the template without change, if you will. So we can go the extra step of actually including in the motion the adoption of the resolution as drafted. I would only add that I think it would be appropriate, if that is ultimately seconded and the determination of the board, to add Graham's memo as an attachment to the resolution. We do attach the ordinance, but I think it helps in the explanation to have it as one document. So that would be I don't need to change the councilman's motion, but if I did.
I'll amend the motion to say we should pass the resolution as written with the addition of Mr. Peto's document.
Can I ask a question? Yes. Go ahead, you can ask a question.
You'd said something, Graham, to what Frank was asking you about, are making recommendations back to the governing body, correct? And that could be around them continuing to look for another available site, is that what?
I think, and Mr. Warner, please chime in, I think that the board has the discretion to, attach or fix additional recommendations regarding the pending ordinance to the governing body to communicate those things. So I think that is something that certainly the board, should there be consensus on those things, could, provide that commentary up along with the findings this evening.
And that is consistent with the law and the standard under the MLUL section and the local redevelopment housing law sections, which are essentially mirror images. I think one gives us 45 days instead of 35. That's the
So I just want to follow
Primary
procedure,
difference.
because we have a motion on the floor, but now we have a question about possibly
a
amending the
recommendation.
motion.
Well, that's up to the movement, whether the movement wishes to amend or not. It's, but we don't have a second yet, so we're not voting yet. So.
Right. Okay,
Well,
Well, we're waiting.
yeah, we're waiting. I don't. The vote.
Well, if she's seconding the original motion, I'd say.
Then
he
we're.
made a motion, and she was asking a question to clarify if we could include some information in our response. But before we had that discussion, now you've seconded the motion, so we can't have that discussion. Which is okay, if that was your intention. Okay,
One of the things I want to clarify is our role today purely to essentially determine if it's inconsistent or further advise on, because Deborah's questions seem like further advisement on what we can do with, towards the master plan as opposed to the ordinance today, which we're determining is consistent or inconsistent with the master plan.
You can make further recommendations relative to the consistency issue, in essence, and but obviously that would have to be the motion seconded and a majority of the planning board voting to do that.
and I just want to make sure I'm on the record saying it is still possible, even though you are a member of the planning board, to attend the public meeting at the TC and make that recommendation, just like any member of the public could go. But in terms of characterizing as the board, I think we should have done that before the motion was made. Apologies. Okay, so you made a motion and Sujatha has seconded it, not inconsistent with the master.
Right, and adopting the resolution with the memo, with Graham's memo March 1 attached there too. So, I'm sorry.
No, thank you. Roll call.
Corey Miller,
Yes.
Michael Cohen,
Yes.
Deborah Nevis,
Yes.
Frank Sagamonte,
Yes.
Sujatha Shan,
Yes.
Srini Vijay,
Yes.
Michael Zion,
Yes?
Gaston Halbert,
Yes.
Beth Saul.
I'm very torn on this, but I will vote yes. I think Graham's memo was compelling, so I'm glad that will be attached as part of the decision. Thank you. Okay, ordinance 2662-24 will be sent and returned to the TC.
Is your memo on the website?
There's one other item I just wanted to mention, just so folks on the planning board know. The township committee will be working towards revisiting our zoning at large, and has asked if we could have representation from the planning board as part of the zoning plan. And I know, thank you, Michael, for kind of reaching out and soliciting input. I believe we have 2 members from our board who will be serving on that committee. It's David Cosgrove and Gaston.
David Cosgrove and Gaston.
So thank you both for volunteering. I know David is absent, but I guess over the coming months, we will hopefully hear periodic updates and can share those as appropriate. Okay, thank you.
I have one question,
Oh, okay, go ahead.
just a process question. I thought back in January, we talked about open, and maybe I don't remember how it turned out, but I thought we talked about providing a Zoom option for these meetings.
We had, thanks for bringing that up.
And, I don't think anything was moved on that. So I don't know, Eileen, if you have were you able to research that or?
I did not, no.
We did raise it, we did speak about it and talked about sort of some complications due to the nature of making public testimony. I don't know if you
Yeah.
can speak a little bit more to that as well.
Happy to do so.
Yeah.
The planning board has certain business, including master plan consistency reviews, that might lend itself to Zoom or what would effectively be hybrid meetings, but our quasi judicial component, our hearings on land development applications, like the site plan application we had recently in Woodland and others, is very difficult, not only in my opinion, but for legal reasons, and it's recognized in case law, it's recognized in the regulations and that are part of the emergency protocols for remote meetings for all public bodies, because, and in fact, those particular protocols and New Jersey administrative regulations separate land use boards and their hearings on applications for development from all other public body meetings, and add additional requirements for them to even be remote in the first place, let alone, they don't really speak to hybrid. The problem, and it's a good problem to have in my opinion, because it's in our state and federal constitution, due process, right of confrontation, etc. It's difficult for credibility determinations to be made, and all the evidence to be seen and understood and heard the same way if some of the people are in person and some of the people are remote. It takes a tremendous amount of technological ability to be able to see and hear everybody the same, particularly when you're also subject not only to the technological limitations that even a great township such as ours has, and it's not unlimited and perfect always, but everybody who participates remotely has their own issues with respect to their own technological abilities, their equipment, etc. So in the hierarchy, in my opinion, in-person meetings afford everybody the best opportunity to have equal access to the information, the testimony, the credibility determinations the board has to make, all the documents, the plans, etc. Remote works to a degree, and has, and we all found that out more so during the pandemic. Hybrid is the most difficult, problematic, and candidly, and it's my job to first and foremost protect the board, and that it makes the proceedings more vulnerable, or to steal from not inconsistent, less invulnerable. Sometimes I don't know. Often I don't know where I'm going. So for those reasons, I recommend against hybrid meetings, particularly with respect to the hearing aspects.
I guess the question is, if we were to limit the Zoom participation to the public comment portion of the meetings, would that reduce some of your concern?
Well, no, because if we're talking about the public comment portion of the hearing,
Over here,
yeah, what you're doing is you're giving people an opportunity to comment, but you're not giving them necessarily the same opportunity to see, hear all the evidence, et cetera, so it dilutes the comments. Now, I'm not saying if we did a hybrid, everything we did would automatically be reversed by a court of law, no matter what the determination was because of the process. What I'm saying is it makes it more difficult for due process and rights of confrontation to be equally shared by all participating. And in so doing so makes us a little more vulnerable, at least a little more vulnerable. So that's why I recommend against it. It's unfortunate because we want to make it as available to everybody as we can.
You realize that on a night like, we didn't have a controversial agenda tonight, but if we did, then on a stormy night like this, that would allow the public to participate more easily instead of, coming out in the rain. But
People could watch, exactly, and same with board members. And I will say that even pre-pandemic, there was an MLUL provision which still exists that allows for, and I'll show you how far back, electronic equipment is the terminology to be utilized by board members if, in certain circumstances they can't make a meeting, which again, if a board member is remote in an in-person meeting, it's my recommendation they not decide the case, but board members can be remote for a non quasi-judicial hearing on an application for development, other business that the planning board does. So those are my thoughts.
And we have alternates, so if a board member can't make it, there's an obvious substitution. And I was really more concerned about having, when we have more heated applications, having it more open to the public.
Yeah, and that's the dichotomy there, and again, it's just it's advice. We have the ability legally to do all in person, do all remote, or do hybrid, and I've given you my hierarchy of recommendations and why, but it's ultimately up to the board to decide.
So said another way, I think, just to summarize, is that, look, it's not necessarily that there would be legal liability, but especially on contentious applications, you're just giving some avenues for somebody to argue that their due process was not followed, or they were not given full due process or something, such as why introduce that element?
Exactly. There generally is always a disgruntled party. It's usually the applicant if it's a denial, and objectors if it's a grant. But there's and certainly I want to make the board as protected, impervious as possible. So,
Well, even regardless of the ultimate outcome, whether they're successful or not,
there's
why sort of tee up potential argument?
a lot here. I mean, it's about the procedure, the result, and of course we'll tell you it's not about the result. That's on the merits. Whether the decision of the board was arbitrary, capricious, or unreasonable or not is essentially the standard. But the process is what you want, regardless of whether it's a grant or denial. You want the process to be as perfect as you can make it and minimize the vulnerabilities. So yeah.
Are there any cases that have occurred where, it ruled against the planning board because the hearing was conducted in a hybrid fashion?
I am not, do you have, wait. I'm not aware of one yet where that was at least the sole reason why there was a reversal of a decision or a remand of the proceedings.
Asked in a different way, are you aware of case law where somebody brought a due process action based on a hybrid? Because quite frankly, I'm not even concerned about the ultimate outcome, the merit to your point. I'd be more concerned about the expense, time, and effort to defend a case just because somebody brought it because we opened up that avenue.
Those types of claims have been made. Yes, those types of claims have been made. And often it's in addition to merits claims and other claims. So,
Thank you.
Sure.
Okay, thank you. Our next meeting is scheduled Wednesday, March 20th. Do we have any completed applications as of now?
There's nothing, there's no applications currently filed or anything.
Okay, we will make our determination then within the next few days if we
I guess
need
by
to have that
Friday.
meeting by Friday. Okay, we will notify the board as well as the public if there's, in the event of cancellation. For now, hold Wednesday, March 20th. I move to adjourn. Do we have a second?
Second?
All in favor?
Aye.
Meeting adjourned. 8:19.
I-
Congratulations.